Welcome everyone to our the last panel of the conference. I'm Kurt Bradley. I'm a professor at Duke Law School. I teach in the international law area. And our last panel this afternoon is on the U.S. relationship to the International Criminal Court. Just thought I'd say a few words by way of background concerning the topic, and then I'll introduce our panelists today. The United States has historically supported the creation of international criminal tribunals. And of course, as many of you know, the United States was involved in the Nuremberg and Tokyo war crimes trials at the end of World War II. And it also supported the creation of ad hoc criminal tribunals for former Yugoslavia and Rwanda, and also so-called hybrid criminal courts in places like Sierra Leone. The United States has also historically supported the concept of a permanent international criminal tribunal, and in fact played a very active role in the negotiations over the Rome Statute, which is the treaty that established the International Criminal Court. The United States nevertheless ended up voting against the text of the treaty at the end of the Rome Conference due to a number of concerns that it felt had not been adequately addressed, including insufficient accountability of the ICC prosecutor, a related danger of politicized prosecutions, and what the United States argued was improper jurisdiction over non-party states. Despite these concerns, the Clinton administration signed the text of the treaty shortly before President Clinton left office at the end of 2000. This act of signing did not make the United States a party to the International Criminal Court treaty. That would have required a separate act of ratification, which for the United States involves obtaining the advice and consent of 2/3 of the Senate. But the signature may have obligated the United States under international law to some connections to the court, in particular not to take actions that would defeat the object and purpose of the Rome Statute, although the precise implications of that obligation are uncertain. At the time his administration signed the treaty, President Clinton said that he thought the Rome Statute still had significant flaws from the U.S. perspective, and that he was not urging his successor, President Bush, to proceed with ratification at that time. President Clinton nevertheless expressed the view that at least with signature, the United States would be in a position to influence the future evolution of the court. About a year and a half later, this was in May of 2002, the Bush administration sent a letter to the UN Secretary General stating that despite the Clinton administration's signature, the United States did not intend to become a party to the Rome Statute. And as a result, the Bush administration took the position that any legal effects associated with the earlier signature were no longer in effect. Some people at the time referred to this as unsigning the Rome Statute, although that can be a misleading term, since the administration did not seek to physically remove the signature, but simply indicate that it did not intend to become a party to the treaty. Subsequently, the Bush administration, with the encouragement, a strong encouragement in fact, of Congress, subsequently entered into about 100 bilateral agreements with other countries, pursuant to which these countries agreed effectively not to extradite U.S. personnel to the International Criminal Court. These agreements are called Article 98 agreements because the United States claimed that Article 98 of the Rome Statute allows for an exception to extradition based on these sorts of agreements. In the last few years, the United States has stopped seeking to conclude these bilateral agreements. It has also appeared, by most accounts, to be more receptive to the work of the International Criminal Court. A notable example is its decision not to block in the Security Council the referral of the Darfur genocide situation to the ICC. And of course, the ICC, relatedly, has been very much in the news lately with its issuance of an arrest warrant for al-Bashir, the president of Sudan, and the United States has appeared to be supportive of this development. We now, of course, have a new presidential administration, and many people are wondering, and it's in part the topic of this panel, which is how this development in U.S. politics will affect the U.S. relationship to the International Criminal Court. Fortunately, we have three extremely well-qualified panelists to address both the past as well as the future of the U.S. relationship. And to introduce them in the order in which they'll be speaking to us today, we begin with John Bellinger. John recently became a partner in the international and national security law practices of the law firm of Arnold & Porter, Washington, D.C. and he's also an adjunct senior fellow in international and national security law at the Council on Foreign Relations. John has extensive experience in the U.S. government, having served as legal advisor for the Department of State from 2005 to 2009, and legal advisor for the National Security Council from 2001 to 2005. He also served as counsel for national security matters in the criminal division of the Department of Justice during the Clinton administration and as special assistant to CIA Director William Webster. John speaks regularly on international law and international criminal justice issues, and in fact was the inaugural speaker a couple of years ago at Duke's Center for International Comparative Law. One of the topics that John has addressed publicly in some detail while serving as legal advisor is the topic of the U.S. relationship to the International Criminal Court. Our second speaker will be John Dugard. John is a visiting professor this year at Duke Law School, and he's held significant teaching positions in a number of countries, in South Africa, in England, and the Netherlands. He has been a member of the International Law Commission of the United Nations since 1998, and has twice served as a judge, an ad hoc judge, on the International Court of Justice in The Hague. From 2001 to 2008, Professor Dugard was special rapporteur to the UN Human Rights Council concerning the human rights situation in the occupied Palestinian territory. Professor Dugard is the author of several books on international law and international human rights. And our third panelist is Todd Lindberg. Todd is a research fellow at the Hoover Institute at Stanford University. He is also the editor of Policy Review, the Hoover Institution's Washington, D.C. based bi-monthly journal. He is a co-author of a forthcoming book that is very relevant to today's panel. It is entitled Means to an End, the U.S. Interest in the International Criminal Court. He has also been involved as an author or editor with several other book projects and is a contributing editor to the Weekly Standard. I've asked each of the three speakers to talk for about 15 to 20 minutes, and then that hopefully will leave us some time for questions from the audience. John Bellinger.
Thanks, Kurt. One of the downsides of being the moderator is that unless you are immodest, which Kurt is not, you don't get to introduce yourself. And so I have to say that in addition to his great work here at Duke Law School, Kurt served as a very able and very well-respected counselor in international law to the legal advisor of the Secretary of State under my predecessor, Will Taft, in the period from 2003 to 2005. And it was wonderful to have Kurt there. Since I left being the legal advisor, I have been decompressing after the last 8 years of the Bush administration, mostly teaching and writing. And one of my favorite subjects has, in fact, been on the International Criminal Court. I've been regularly talking about what has been really the theme of this conference, challenges and opportunities in international law for the Obama administration. One of them is obviously the challenge and the opportunity of closing Guantanamo and doing something about the detainee issues. But second on my list has been how to address the International Criminal Court, which is, I think, both an opportunity for the Obama administration, but it really is going to be a challenge. And I think that this, as in some other areas, is going to be something where the international community is expecting far more than the Obama administration is going to be able to deliver, and there's going to be some disappointment. What I'm going to do is talk a little bit about the last 8 years of the policy of the Bush administration towards the International Criminal Court, and then talk about what I would predict is going to be the future. So I just want to drill down a little bit deeper into some of the facts that Kurt mentioned, the most important of which is the one that people quickly forget, and it is that the core of U.S. government policy going forward, and I have to say many people, but particularly Rome Statute members forget this, is that while the United States had historically supported the idea of an international criminal court, was active at Rome, and President Clinton signed the Rome Statute, he did say that it was fatally flawed and that he was not going to submit it to the Senate and that he was not going to recommend that his successor submit it to the Senate. And so any U.S. government policy under the Obama administration has got to be read against that backdrop. Now, in 2002, from 2001 to 2002, there was deep concern amongst high-level officials in our administration about the International Criminal Court. As people know, there were a wide variety of views in our administration, but there were a number of people who felt very, very strongly, including Secretary Rumsfeld and the Vice President, and others as well, who felt that it was a fundamental violation of international law to have a treaty like the Rome Statute, to which the United States was not a party, assert jurisdiction over the United States. And as most of you know, that's one of the fundamental principles of the Rome Statute, that it would apply to non-parties. So, as Kurt said, after internal debate inside the U.S. government, President Bush authorized essentially the withdrawal of our signature. You can't snip out your signature, but we notified the United Nations, the depository of the Rome Statute, that we formally did not intend to become a party. From 2002 to 2000, and I want to, for people who are interested in this, it's very important to look at the speech that was given at the time by Mark Grossman, who was the Undersecretary for Policy at the State Department, which was the definitive statement of U.S. policy at the time. And contrary to what many people think about the Bush administration's policy, this was a very soft, moderate speech that said, we have these concerns about the Rome Statute. That's why we're formally going to state that we're not going to become a party, but that we share its goals. We believe in accountability for those who have committed crimes against humanity, war crimes, genocide. We are committed to human rights. We believe there is common ground, and we ask others to meet us there. We respect the decision of others to become party. We ask them to respect our decision not. It was a very moderate in tone speech. Unfortunately, from my personal perspective, U.S. policy then took on a different tone from about 2002 to 2004 as we pursued Article 98 agreements to protect our forces around the world and to comply with obligations under the American Service Members Protection Act, which I will parenthetically say was something that was initiated by Congress. In fact, the White House had some concerns about the constitutionality of it, although we were supported its thrust. But from 2002 to 2004, there was a relatively a hostile tone towards the International Criminal Court, which led, I think, many around the world to believe that the Bush administration wanted essentially to try to kill the court in its infancy, throttle the baby in the crib. At the turn of after the election, I, as the NSC legal advisor, wrote a transition paper for Secretary Rice saying, I thought this was a major problem for us, that countries around the world believed that the United States did not believe in international criminal justice, in international institutions, that if you asked any person on an international law subject around the world, that within the first two sentences they would list the U.S. opposition to the International Criminal Court as an example of why the United States did not believe in international law, and it had become a symbol and essentially a tempest in a teapot. And I said, we really need to address this in the second term. And the Secretary gave me the quiet green light to work on this for the next 4 years. And so for the next 4 years, we adopted what I would say is a much more pragmatic and nuanced approach towards the International Criminal Court, which I think was largely successful in both tone and actions. In tone, I in particular, but others in the administration, gave speech after speech after speech, which really harkened back to the Mark Grossman speech, that we respect the decision of other countries to become party to the International Criminal Court. You need to respect our decision not to become party. I started using an expression that Javier Solana, the EU foreign policy czar, had actually coined, that we need to have a modus vivendi, that we need to essentially just coexist. Countries can get along well with each other even if they disagree on policy. And that we could work together even though we were not a party to the ICC because we shared its goals. Now, as Kurt said, within a few weeks of Secretary Rice's becoming secretary, we had an opportunity essentially to put these words into action with the Security Council referral of the Darfur situation to the International Criminal Court. And the United States, instead of vetoing that, abstained because we were more concerned about the situation in Darfur and the genocide that had occurred there than we were about the International Criminal Court. at the time. And we got significant recognition for having done that. But we then went on to say that we had not just sort of let this happen and we would let the chips fall where they may. We then had a series of actions supporting the ICC's investigation in Darfur. We made a number of public statements saying that we wanted that investigation to proceed. I gave a series of speeches in which I said if the ICC prosecutor needed assistance from the United States government, and it was something, an appropriate request and within our power to provide, that we would provide intelligence support or other support to that investigation. In a related matter, when Charles Taylor was captured and was to be prosecuted before the Special Court for Sierra Leone, but the concern amongst African countries was that it would be too dangerous for him to be prosecuted at the locus of the Special Court for Sierra Leone in Africa, we told the ICC that we had no objection to his being tried by the Special Court for Sierra Leone sitting in the ICC facilities. I personally called up Philippe Kirsch, the president of the ICC, to say, we are not allergic to the bricks and mortar of the ICC. We believe in international criminal justice. Our views of the ICC are well known, but that doesn't mean that we are trying to delegitimize it. And then finally, by the end of the administration, our policy had almost come full circle in that when the prosecutor, Luis Moreno Ocampo, sought an arrest warrant against President Bashir of Sudan, and other countries, primarily in Europe and primarily led by France because they were under pressure from African countries, and I think you heard Ambassador Hussein explain some of the reasons last night, began to support a deferral of the arrest warrant under Article 16 of the Rome Statute, which allows the Security Council to defer an investigation or prosecution. And we had one of the principal supporters of the Rome Statute, who had lost no opportunity to bash the United States over the last 8 years for our non-support of the ICC, France, then essentially undercutting the prosecution of Bashir. We made clear publicly that if there were an effort in the Security Council to defer the arrest warrant against Bashir under Article 16, that we would veto that effort. So by the end of the administration, our policy had become, I won't say quite full circle, but maybe 3/4 of the way around the clock, to certainly say a more pragmatic approach, so that the United States went from being the principal antagonist to the ICC to, at least in this case on the arrest warrant, being one of its principal supporters. Now, that leads us to the present time, and I just want to say a couple of minutes about what we can expect from the Obama administration. One, as I said, I think it's just, there's a feeling, I think, amongst some around the world, particularly those who know the ICC issues less well, that the Obama administration will, of course, just turn on a dime and seek to become party to the ICC because they believe in international law and we didn't. That's not going to happen. Obama would have to say, well, President Clinton was wrong when he said that the Rome Statute was fatally flawed. He would have to have continued opposition, I believe, and there are many military people in the room who would not be interested in their views, but I would predict that the views of the military are going to be the same, that they have the same concerns now that they had in 1999, which led them to not support the Rome Statute as drafted. So I don't believe that Obama in the next year or two is going to support immediately becoming party to the Rome Statute without changes. And frankly, if he were to try to just send it to the Senate, I don't think that the votes are there in the Senate. Right now, there will be many voices who are going to throw back at him, well, wait a minute, President Clinton said it's fatally flawed. What's happened in the last 8 years that's made it unfatally flawed? So I think what we will see, though, is a much more supportive tone towards the ICC. I think that will actually be a continuation of the policy that we had in our second term. I think, frankly, at the most macro level, not even talking about the ICC, you will see that the there will be more continuity between the Bush administration's second term and the Obama administration on international law issues than between our first administration and our second administration. So I think you will see a warmer tone. I suspect you will see the Clinton or the Obama administration join some of the ICC's institutions, like the Assembly of State Parties. There is a working group that has been working on the very important definition of the crime of aggression. Some of you know this, others of you may not, that at Rome, it was agreed that the Rome statute, or that the ICC would have jurisdiction over genocide, crimes against humanity, war crimes, and the crime of aggression. John, were you there?
No.
But you probably know more of the history than I do. But the drafters could not agree, the parties could not agree on the crime of aggression, so they left it undefined to be worked on for the next 10 years, and there's been a working group that's been working on the crime of aggression. I've been actually a little surprised that as we're into the third month of the Obama administration, I would have thought that would have been low-hanging fruit for the Obama administration to join those discussions, because the United States has a critical interest in getting that definition right. The country that is more likely than any country in the world to be accused of aggression, even though we don't think of ourselves as aggressors, but simply because our military is in more countries in the world, just statistically, is the United States. So we have a vital interest in that definition. I would expect the working group's work is now done, and the Obama administration missed that opportunity to participate. Now, the definition is not locked down. Now, I think we will, and I'll say a word more about that in a minute. So I think during the next year or so, we will see a more supportive tone of the ICC, participation in some of the ICC institutions, more offers to support the prosecutor in some of its investigations. What I want to end with is what I think is going to be the $64,000 question, and which is going to be really interesting, is there will be a review conference to review the progress of the ICC in 2010 in Uganda? Uganda, exactly. And the question for the Obama administration will be, what tack do they take at the review conference? They will undoubtedly go. If my putative successor, nominated successor, Harold Koh, the dean of the Yale Law School, is confirmed, I would expect he would be the head of the U.S. delegation. And the question will be, if I'm right, that the Obama administration would not be able to become party without changes to the Rome Statute because of the history under the Clinton administration, that they will go to the review conference and try to convince the rest of the world, the Rome Statute members, to say, we very much want to become party, but we cannot sell this back home to our Senate and to the American people unless changes are made. And if you make changes, then we will try to become party. The pressure will then be put on the other countries, and it will divide between pragmatists and idealists in the world. And the pragmatists, I expect maybe like the British government or others, will say, we cannot run an international criminal tribunal, sort of big picture principles aside, just practically without the involvement of the United States. We need their intelligence resources, we need their diplomatic resources. If someone is arrested, the UN has no airplanes. It's the United States who can go and pick people up and bring them back. We need the United States. The more idealistic countries, who I think are in the majority, though, will say, no, no, no. This is the debate that we had 10 years ago in Rome, and we cannot give in to American exceptionalism. It is more important to be true to our principles, that there can be no exceptions. We cannot give the protections to the United States government that they want, and so we cannot make those changes. And I would predict that the United States government will leave the review conference disappointed. Now, the last point I want to end on is to go back on this definition of the crime of aggression. At least at this point, the crime of aggression was left undefined and will need to be filled in at the review conference. If the parties in Uganda adopt a bad definition of the crime of aggression and, more significant, then apply it to the United States, which is not a party to the Rome Statute. So we have an overarching definition of the crime of aggression. Let's say any unauthorized use of force against another country. And then it applies to the United States, who, as I said, were unable to convince the other parties to make the changes to the Rome Statute that we wanted, so that the potential would be the United States would leave Uganda with no changes to the original Rome Statute, a definition of the crime of aggression that applies to the United States even though they're not a party. Then there will be a train wreck. And the military, I think, will not stand for that, and that the Obama administration will have a very difficult time on their hands. So the opportunity for the Obama administration over the next year or so, I think, is to continue what we did in our second term, which is to adopt not only a more pragmatic and nuanced approach to the ICC, but, in my personal view, a more supportive view of the ICC. To continue to do that, but to develop a policy going into the review conference that will try to make changes to the Rome Statute, as I think that will be a very heavy lift, but if not, at least to get changes to this crime of aggression so that there will not be a train wreck in 2010. Thanks.
Thanks a lot, John. And we'll now hear from Professor John Dugard.
Thank you, Kurt. I presume the microphone is working? Yes. I'm going to comment this afternoon on a report prepared by a task force of the American Society of International Law on the subject of engaging with the International Criminal Court. And let me just say that this task force has not recommended that the United States should immediately join the International Criminal Court. It has, however, recommended that the United States should work towards a closer relationship with the International Criminal Court. And let me just indicate that its members are fairly well-known international lawyers, respectable, hardly radical, William Taft, Patricia Wald, Mickey Edwards, Michael Newton, Sandra Day O'Connor, Stephen Schwabel, David Talbot, and Ruth Wedgwood. So it's a very responsible and cautious report which recommends that the United States reconsider its attitude towards the International Criminal Court. I must say that I think this is an excellent report, and I do think that it is important that the United States engage in such a closer relationship. It's essential both for the United States and for the International Criminal Court. As Kurt Bradley pointed out, the United States has long been an advocate of international accountability. It was largely responsible for establishing both Nuremberg and Tokyo tribunals. I think one should recall that both Churchill and Stalin favored simply disposing of the major Nazi war criminals without trial, and that it was the United States that insisted on trial and that it should be held in accordance with the principles of due process. And since then, the United States has also supported other ad hoc tribunals in different parts of the world. I think one can safely say that until the United States refused to become a party to the Rome Statute, it was seen as the leading state in the fight against impunity and in favor of accountability for the commission of international crimes. So I believe that having regard to this history and to the traditions and values of the United States, that the United States really belongs in the International Criminal Court, and it should become a member, albeit not immediately. Perhaps I could now say a few words about why it is good for the International Criminal Court, or would be good for the International Criminal Court, that the United States became a member, particularly at this time when the International Criminal Court faces a crisis arising from its issuing of an arrest warrant for Omar al-Bashir of Sudan. I tend to have the rather old-fashioned view that any international body without US participation is doomed to failure. And I think in this respect one only has to mention the case of the League of Nations. But there are other examples. The Human Rights Council has suffered seriously from the absence of the United States, and I'm delighted that the United States will join that body, however difficult it may be. I don't think that the International Criminal Court will survive without US participation, or at least without the support of the United States. I think that if the United States did become a party, it would send out a clear message to other major powers, particularly the Russian Federation and China, which are less concerned about fighting impunity and promoting international accountability. And of course, there are also the I states, which I think create an even greater problem for the International Criminal Court. That is Iran, Iraq, India, Indonesia, and Israel, all of which have refused to ratify the Rome Statute. And I think that if the United States adopted a different attitude, they might reconsider their position. But looking at the International Criminal Court from a practical perspective, I think it's very important there too that the United States should become a member. First of all, there is the judiciary of the International Criminal Court. It's rather a strange bunch of judges. At the Rome conference, the NGOs and many delegations wanted a court that was more gender sensitive and that comprised practicing judges or lawyers with criminal law experience. Well, that has materialized as far as the gender balance is concerned, because today of the 18 judges, exactly a half are women. But unfortunately, judges or countries have not nominated their best judges for the court. The European countries in particular adopted a very unfortunate attitude. They nominated senior diplomats to become members of the court, and many of them are still members of the court. The latest election was slightly more promising because of the 5 candidates who were, of the 6 candidates who were elected, 5 were serious international criminal lawyers or practicing national criminal lawyers. I think that if the United States was represented on the bench of the International Criminal Court, it would improve the quality of the court. One must remember that the United States has a proud tradition of nominating good people for international tribunals. One can think in particular of the International Criminal Tribunal for the former Yugoslavia, where the United States has been represented first of all by Gabriela MacDonald, then by Patricia Wald, and now by Theodore Meron. So I think a good American judge on the court would provide leadership, judicial leadership in the court, and also send out a clear message to other states that they should nominate better candidates for the court. There's also the question of the development of the rules of procedure of the International Court at this early stage. As you know, the court reflects both civil law traditions and common law traditions, and there is a trend in favor of the civil law inquisitorial procedure. at the expense of the accusatorial system, and I think that an American judge on the court would do much to restore a balance, a very necessary balance. So there are practical considerations why it would be helpful if the United States were to join the court. I would now like to turn to another issue, and that is the question of what has troubled the international community about the United States and the International Criminal Court. In some cases, the attitude of the United States has angered the rest of the world. In other cases, it has simply puzzled the rest of the world. When it comes to those factors which have angered the rest of the world, I think one thinks immediately of the American Service Members Protection Act of 2002, which not only restricts U.S. cooperation with the International Criminal Court, but also authorizes the President to use all means necessary to free its service members who may be detained or imprisoned by the ICC. And in The Hague, where I am currently resident, this is known as the Hague Invasion Act. We fear that the United States will invade The Hague to release an American prisoner. And then, secondly, there are the Article 98 agreements which ensure that states that sign these agreements will not send U.S. nationals to the International Criminal Court. And of course, there's the Nethercutt Amendment associated with this, which prohibits the United States from giving assistance to any country that is a party to the ICC statute. These measures in particular have been seen as hostile acts in respect of the International Criminal Court, as John Bellinger rightly pointed out. In some quarters, it was seen that the United States had declared war on the court. I'm delighted that the task force has recommended that both these measures be reviewed, amended, and possibly scrapped. Now, what has puzzled the rest of the world? Well, in the first place, I think we've all found it rather puzzling that the United States has objected to the fact that the International Criminal Court will have jurisdiction over U.S. nationals. It is suggested that no foreign international court should be competent to try a U.S. national. But of course, we all know that American nationals who commit crimes abroad in some of the least friendly states are tried by the courts of those countries, however low their standard of justice may be. I'm very pleased that the task force has decided that these criticisms were unsubstantiated and that there is no violation of international law by providing for the trial of American nationals by an international court. Then there's also the argument that has been raised in favor of trial by jury. It's argued that no criminal court can try a person without a jury. Well, this seems strange to other countries where criminal trials are routinely heard by a professional judge, and also international criminal courts that have been supported by the United States have not established juries. The Nuremberg Tribunal, Tokyo, the various ad hoc tribunals are all presided over by panels of judges without jury. In fact, one could hardly conceive of a jury system operating at the international level. Another objection that has been raised is that the International Criminal Court does not comply with US standards of due process. The task force has also repudiated this. It has indicated quite rightly that the International Criminal Court is bound by the rules of due process contained in the International Covenant on Civil and Political Rights, and that these do, to a large extent, reflect American notions of due process of law. As to the power of the prosecutor, this too, I think, has been overstated, as the task force finds, because the prosecutor of the International Criminal Court is subject to many checks, particularly by the pretrial chamber. On another issue, John Bellinger has referred to the debate over the crime of aggression. I do not believe that it will be possible for the review conference to reach agreement on the crime of aggression. I think the differences, particularly relating to the role of the Security Council in the enforcement of the crime of aggression, are too great. And I just don't think that this will constitute an obstacle in the way of American participation. So, in conclusion, let me say that I strongly welcome the report of the Task Force of the American Society of International Law. I hope that it will be followed. One of its important recommendations is that the United States should adopt legislation itself to enable US courts to prosecute the crimes defined in the International Criminal Court: genocide, war crimes, and crimes against humanity. There is already US legislation for the crime of genocide. Some of the war crimes are criminalized in the United States, but not all the crimes contained in the Rome Statute, and the crime against humanity also requires further elaboration in the United States. So I think it would be very helpful if during this interim period, while the United States reconsiders its position or enters into a closer relationship with the International Criminal Court, that it got its own house in order by enacting legislation which enabled American courts to prosecute persons for the commission of international crimes. Because after all, the main protection to be found in the International Criminal Court statute for member states is the principle of complementarity, which recognizes that in the first instance, every member state should have the opportunity to do justice in its own courts, and that the International Criminal Court is simply a residual court, a final residual court which may be resorted to if justice cannot be done at the national level. So I think that's a very important contribution. Something that I find very strange about the United States is that one of the complaints about the International Criminal Court statute is that it allows universal jurisdiction, which is not correct. It only allows jurisdiction in the case of crimes committed in the territory of a member state or by a national of a member state. But I cannot understand the aversion of the United States to criminal universal jurisdiction when the United States has the most far-reaching universal jurisdiction statute in the world, the Alien Tort Act. It's not for criminal jurisdiction, but it's for civil jurisdiction. And this statute is vigorously protested by other states because it is such a radical exercise in universal jurisdiction. So given this piece of American law, I can't quite understand why the United States is so concerned about extraterritorial jurisdiction. Let me conclude then by saying that I am delighted with the recommendation of the task force of the American Society of International Law. I hope that its proposals will be adopted by the Obama administration, and that while one cannot expect the Obama administration, for reasons pointed out by John Bellinger, to immediately join the International Criminal Court, I hope that it will move in that direction, because I'm quite sure that in the future, certainly the foreseeable future, the United States will become a member of the International Criminal Court. Thank you.
Thank you, Professor Dugard. I had thoughts about your comment at the end, John, about the Alien Tort Statute, but I think we can save that. I think John might have as well. We'll save that for later. Our third panelist is Todd Lindberg.
Thanks, Kurt. Thanks to Duke Law, and I also want to say a word of thanks to the New Ideas Fund, which is supporting my current work on this subject. The manuscript for the Brookings Institution book that I've written with Lee Feinstein being at the copy editor, while one looks for ways to go on. I am, by my own count, the 28th speaker at this conference, and that's counting Scott Silliman only once. And I guess the way to start is just with the good news, which is that I'm also the last speaker at the conference. And I'm in an unusual position, which is that I am in substantial agreement with the analysis that my two previous co-panelists have proffered. My disagreements with John and John would, I think, amount to footnote kind of questions of nuance, and I think that this is true both with regard to the analysis of the court, of the operation of the court so far, and with regard to its future prospects. That, you might think, would complete my remarks. No, I'm afraid that will not be the case. I also bring a non-lawyer's perspective, I think, to the panel. And I think that that's important because since the period in which we had our train wreck in the United States over the International Criminal Court, we have lost sight of the fundamental question. And the fundamental question is, what do we do about perpetrators of mass atrocities, up to and including genocide, who are not going to be prosecuted locally? Are they essentially going to find themselves in a position of hiding behind sovereignty claims and thereby escaping being held accountable for their actions? Now, I submit that the proposition that people who commit these kinds of crimes should be held to account is something that is a dear and well-established American principle. It's not the only principle of morality in politics, or even the only principle of practical foreign relations. However, and there are instances, of course, in which, frankly, we will find ourselves balancing this good, which is to say accountability, against other goods, for example, the possibility of a peace agreement. But I don't think there will ever be an instance in which we will say, well, we really don't care about the justice end of this. That period, I think, in the United States disappeared in the first instance with the Lieber Code during the Civil War. And obviously, a principle, again, honored not only in the observance but also in the breach, a greater willingness to hold others accountable, perhaps, than to hold ourselves accountable in certain instances. But nevertheless, I mean, I think the principle is there, and it deserves to be elevated. I think we need to quit looking at international justice through the prism of our dispute over the International Criminal Court and start looking at the International Criminal Court through the prism of our longstanding effort to hold people to account for very bad crimes. Can the International Criminal Court be useful? And I conclude that the answer to that now is yes. What is the purpose of the International Criminal Court? Well, now when this at the time of the drafting of the Rome Statute, let us be candid, there were some very different views about the purpose of the court. There was the more narrow, lawyerly view, and the one that I think ultimately is correct and has been vindicated, which is to say a court of last resort for the pursuit of the worst offenders in cases where there is no complementary national justice system to hold them account. But others had different visions, and let us be frank. Some saw the creation of the International Criminal Court as a building block in a broader project of global governance. Some saw it as a possible way around the lock on peace and security questions that the Security Council possesses, and in particular the strength of the veto powers. And in addition, coming from the other side, and partially in response to some of these broader ambitions on the part of some of the proponents of the court, there were the reactions to these kinds of considerations. And that took the shape, I think, of a concern that the International Criminal Court was somehow fundamentally anti-American in its contour, that the prosecutor would be looking for instances, especially to hold Americans to account, that we would have no effective protection for Americans in relation to the court, and that therefore we ought to stay as far away from this as possible. Now, I submit that these are two ideological readings of the court, and they were both offered prospectively, which is to say, before the court began operation, as a kind of theoretical analysis of the emerging Rome Statute, and then in the immediate aftermath of its adoption in Rome. And these positions are still they're very much a part of the American debate on the court to this day, and I don't think we should minimize this. If the Obama administration brought the Rome Treaty to the Senate floor for ratification, there would be a battle royale. It would be a very unattractive political spectacle, and I agree with John. I doubt that under the current circumstances there are the votes for ratification at the moment, and that is because of the depth of the concern in opposition in relation to some of these other aspirations for the court. Well, John asked an interesting question, and here would be one of my footnotes. He asked, what has happened in the last 8 years to make the Rome Statute perhaps not fatally flawed as the Clinton administration described it? And I do think that there is a bit of an answer to that question. And the answer to that question is the operation of the court. The court has been, in its operation, extraordinarily circumspect. It is not a strong institution. It is a relatively weak institution. It has funding issues. Rather than a prosecutor who's hastened to crusade willy-nilly in advancement of a broad human rights agenda or some other political agenda, we have a prosecutor who has taken jurisdiction in cases in which state parties asked him to take jurisdiction, and in which the Security Council referred a case to him for consideration. He has not acted in accordance with his power to initiate a case on his own, and he has indicated that he regards, I think, the legitimacy of his prosecutorial activity to be a matter of some importance to him. Meanwhile, on the judge's side, we have seen a substantial effort, I think, that has been expended to ensure that defendants' rights are protected, that there are adequate safeguards in the process. Do these safeguards, protections for defendants, mirror those that are in place in the United States? No, they do not mirror, they are not the same, but I don't think anyone could reasonably look at the protections that have been built into the into the ICC for the ICC's operation for defendants, and conclude that they are out of line with what we would routinely regard as respectable by any reasonable international standard with regard to these things. They are different but equivalent in that respect. And we have seen the willingness of the court to act in response to a Security Council request for it to take jurisdiction in the Darfur case. The progress of that case has opened a new chapter in international relations, and one, frankly, to which I do not, and I don't think anyone knows the ending. Obviously, we're in an area of uncertainty with regard to the future, but at the same time, I think it's important again to note that the court has done of it what we in the United States also, per John's many speeches on the subject in support of John Bellinger's many speeches on probably John Dugard's too, in support of the prosecutor in these matter. In this matter, have wanted. We've seen this case proceed and develop. It has done so responsibly. And I would note that the review, the panel of judges that reviewed the prosecutor's request for the warrant for Bashir actually turned down the prosecutor on the genocide count, citing insufficient evidence of intent. And that too, I think, is an indication of the seriousness with which the institutions of the court take the role that they have to play. So it seems to me the United States has 4 possible choices going forward. One is to continue a policy of John's going to disagree with me here, of hostility, or a policy that will be perceived to be hostile, or to resume such a policy. The second would be, I think, a policy of essentially benign neglect of the court, a policy, in other words, that would engage the United States with the court as little as possible, and essentially try to work around it, no effort to bring clarity toward U.S. policy with regard to the court, rather a kind of just acknowledging a kind of empty space where the court operates. A third would be to move quickly toward ratification and to become a member of the Assembly of States Parties. And the fourth would be what I think is the most practical course and also the right course for the moment, which is to implement a policy of cooperation with the court that essentially has the United States in the room where possible as an observer at the Assembly of States Parties, involved in such considerations as the deliberation over the definition of aggression, assisting the prosecutor in investigations when that is appropriate, perhaps participating in contributions to victims' funds and other such ways, and in general, trying as best we can to get a sense of how the court will respond to a sincere American effort to cooperate with it. My expectation is that the court would welcome such an effort, but I don't know the answer to that question, and I would like to know the answer to that question. We have some benchmarks ahead of us. Obviously, the review conference is one. I agree with John that with both the panelists that the crime of aggression question is of great importance to the United States. I would not necessarily expect the Obama administration to go in with a view toward trying to modify the fundamental structure of the court, which is to say, essentially, I suppose, if I understand you, John, to require essentially a Security Council referral for jurisdiction or allow for it in cases of self-referral, but not to allow the proprio motu for the prosecutor to act on his own motion. I think that would be an awfully big ask for the United States in exchange for an effort to become a state party But I think that it might be possible to make some progress on the aggression definition, or at least to end up in a place that John Dugard just described, in which no agreement is reached because no agreement is possible, which is probably a situation with which the United States can live. So we have the review conference. The prosecutor's term serves a 9-year term, which is not renewable, is up in 2011. It will be interesting, I think, for the United States to see what the process is like for the selection of a new prosecutor. It will be interesting to see whether that new prosecutor essentially reaffirms some of the encouraging statements that the current prosecutor has made with regard to questions of jurisdiction and complementarity and so forth. I think that's something that the United States will want to look at very carefully. There will be, I think, instances in which, at this point, it seems to me at least unlikely that the United States would support the creation of another special tribunal to deal with a situation involving atrocity crimes. We have now the precedent of the Darfur referral. Of course, at the time we assured everyone that we did not regard this as a precedent. Well, it is a precedent. And I would think that the next time around, the question not being unprecedented, that we ought to be able to support, in other words, vote for a resolution referring a matter to the International Criminal Court rather than simply abstain. And with regard to the prosecutor's propria motu power, well, yes, he's been extraordinarily judicious and has not acted in accordance with this power that he possesses, but I don't think it is at all inconceivable that there may come a time when an effort at the Security Council to refer something to the court is blocked on the Security Council, not by us. And at that point, the United States will be presented with a very interesting question, which is, could it support, actually, a request by state parties or others? Could it join such a request for the prosecutor to take jurisdiction on his own motion? And what will be the process by which the prosecutor and the court more broadly act under such circumstances to ensure that their actions are perceived to have an adequate level of legitimacy? I will not go on really much longer at all without the claim of jurisdiction over the nationals of non-parties. They had a different view, they had a different set of priorities, they got their way, and I think the price of this is the delay. It is 10 years of the United States being in a position of, if not outright opposition, then wariness, and if moving out of wariness, edging into cooperation. We will now enter a period of cooperation, and we will see where that takes us. I think that eventually the court will resolve in practice my hope, what it was not able to resolve to the satisfaction of the United States in the crafting of the Rome Statute. Thanks.
Thank you, Todd. Before, we're going to move to questions soon, but I thought I might give, particularly the other two panelists, just a minute or so if they wanted to, having now heard all three presentations, if they wanted to make any remarks in response, and then I'll be sure to open it up for questions. John?
Wonderful. It's nice to have a chance to rebuttal. I will pick one point with respect to John and one with respect to Todd. John has made the argument that I hear as the legal advisor of the State Department and principal representative of the United States on legal issues around the world, the sort of the European view of why it's in the interest of the United States to become part of the International Criminal Court and why it's in the interest of the International Criminal Court and the international community to have the U.S. become part of it. And I don't disagree with any of those things. I think as an American, as a believer in the rule of law, as someone who comes from a military family, as someone who's aware of my American history, I agree with all the points that the United States could usefully be party in a fine American tradition of the International Criminal Court. And I discussed myself the interests of the court in having the U.S. be part of it. I think all that's irrelevant. what I'm trying to bring, let's just accept that as a given. And by irrelevant, I just mean it's accepted as a given. But to move forward, we're now out of the world of nice arguments and more into the world of United States politics, both bureaucratic politics and American politics. We can come up with all of the great arguments about why the United States should be party and why it's in the interest of the ICC to have it become party. But for that to happen, two things have to happen. Obama has to make that decision that he either wants to become party, either with or without changes to the Rome Statute, and then the Senate has got to approve it. In the first instance, unless I'm shocked, and maybe I will be, because President Clinton said it was flawed, and because the military will continue to have many of the same concerns, and because Obama, frankly, his one Achilles heel is going to be he's going to be accused by the right of being sort of weak on defense, is that he can't just turn around and say, well, I actually think it's fine for American service members to be delivered to an international criminal court without changes to a statute that my Democratic predecessor says were flawed. So I've been in lots of meetings inside the Situation Room, and I just think that it will be very difficult bureaucratically for him to simply overrule the recommendations that I expect are coming from the military. So I think he would have to go into a review conference seeking changes. Then you get to the realm of international politics, or of domestic politics, which is that even though there's a Democratic majority in the Senate, it's going to be it's too easy for people to grandstand around the United States and say, and we're going to deliver U.S. servicemen and women who are fighting for us to foreign prosecutors in The Hague where they're not going to have protections. I mean, you know what our Congress is like. People can make lots of high-minded arguments about American values, but it's going to come down to what their mailbag is actually saying. I spent much of the last 2 years trying to get the Law of the Sea Treaty approved, which is absolutely in our interest, uncategorically in our interest, and doesn't involve any Americans being delivered anywhere. And yet, we still couldn't get that through the Senate. So I think that despite all the arguments that I agree with you, John, that I just think it's going to be tough sledding to even get the administration to agree to support it unless it's changed, or to get the Senate to approve it. And Todd, I guess my point to you is just slightly related. Well, one, I would not call the Bush administration's second-term position hostility. We moved from hostility, I would say, in the first term to what I think you call but somewhere between benign neglect and cooperation in the second term, and I think most people would accept that. Your point of, well, will we go into the review conference seeking changes? I just don't, you're right, it will be very difficult going in to get those changes, probably impossible, but I just don't believe that the Obama administration could go into a review conference saying that after the last 10 years of watching the operations of the court, that we've come to accept that it's fine. I just don't think that reflects the realities in Washington. I think they have to go in seeking some changes.
Thanks, John. Any other panelists want to say something in response to each other?
Well, I just wanted to add a note of caution in respect of what Todd said about the United States in all likelihood being prepared to support another request for referral of a situation to the Security Council. And one should bear in mind that the most likely next request for referral will come in respect of Israel and Gaza. And I can't see the United States being very supportive of that. And I should mention in this respect that there is at present an attempt on the part of the Palestinian Authority to have the matter considered by the ICC. The prosecutor is considering the question of whether Palestine qualifies as a state. If that avenue fails, there's always the possibility that there may be a request to refer the situation, the Gaza conflict, to the ICC through the Security Council, and that of course is going to be a real spanner in the works for the Obama administration.
Thank you. Okay, I think we can now move to questions. And please.
Thank you. My first question is for Mr. Bellinger. My understanding was that one of the objections the U.S. had to the Rome Statute was that the United States not being a signatory to the statute, that we would somehow be subject to the terms of the statute. My first question is my understanding is that Sudan is not a signatory to the Rome Statute. Is that correct?
Not a party.
Yeah.
Not a party, not a state party. So, but yet we would support Sudan being subject to an indictment under the ICC. How do you square that with the American position that it's somehow inappropriate for the United States to be subject to the statute or the terms of the statute of the court when the United States is not a party, a state party to the statute?
The way we squared is that the Sudan was only subject to the jurisdiction of the Rome Statute because of the referral by the Security Council. And that was, as both my colleagues said, was what we had sought in Rome, because the United States was concerned that just not because of a perception that we might ever do anything wrong, but because just statistically we are more exposed than any country in the world. It's very easy, candidly, I think you get a sense I'm being fairly candid here. It's very easy for a Sweden or a Finland or someone to talk about high principles of international criminal justice, because it's very unlikely that any Finnish official or soldier is ever going to be brought accused of a war crimes violation. But just statistically, the United States military is got operations in many, many, many countries around the world, either as part of peacekeeping missions or part of our own missions. And so they're just more likely to be accused of something, even though we wouldn't think they'd have done anything wrong. So what we sought at Rome was that we wouldn't be able to be subject to the court's jurisdiction simply because our actions took place in a Rome statute party, but only if the Security Council approved it. And so with respect to Sudan, we actually got what we had wanted, which is only the Security Council had approved the referral of the Darfur situation to the ICC. So there was that trigger. As I say, I think Todd's probably right. It's a bridge too far for us to try to get that at the review conference. But that is what we have sought for that ultimate safeguard for U.S. officials.
Thank you. And just one follow-on question is, the U.S. is concerned that even though the concept of preemptive self-defense is more or less taken out of the toolbox right now, I think under the current administration, would it be one of your concerns that preemptive self-defense may be viewed as an act of aggression under the new definition?
Potentially. I don't think the new administration has taken anticipatory self-defense out of the toolbox. And I think they've said very clearly that if they see threats emanating from another country like Pakistan or Yemen or Somalia, that they would take the action necessary. And yes, I do think that's one of the things that, the United States, because we are able to use force and there are more threats against us, we do use force. And we are frequently accused, you probably don't hear it, I do, because I've been in a lot of these capitals around the world. Every time the United States does something in Afghanistan or a predator strike or something like that, the buzz in different European capitals is that was an aggressive act, that was an illegal act, that was a criminal act. Now, admittedly, no ICC prosecutor has done anything, and I do think it is highly relevant that the prosecutor has not taken any action against the United States and in fact turned away suggestions that he should prosecute U.S. officials for the Iraq War. But nonetheless, there is that concern in the background that we could be, that our actions could be subject to ICC jurisdiction.
I think we have a question over here.
Todd, I told you I was going to ask you. I told you at lunch I was going to ask you this question. You alluded to it in your initial remarks when you stated that part of the opposition to this statute is the concept of a incremental move toward globalization. I think that's also the problem with the law of the sea treaty, frankly. And I'm wondering, and I'm looking for an argument against that proposition. What will the three of you, how can the three of you help me argue against that proposition?
Well, I think to begin with, you actually have to look at what the court is going to do and what it says it's going to do. Now, I don't say that that the court has dispelled all doubt the United States might have about its future actions on the basis of what it has done so far. But there is a very clear pattern that has emerged so far, and that is that it takes itself seriously in the role of court of last resort for worst sort of criminals. And if you look at the statements that the prosecutor has made about the cases that he has taken, about the cases that he has not taken, including the Iraq request, which is actually a very interesting, the letter that he wrote in response to that is actually quite interesting. The statements that have been made by the prosecutor with regard to the respect for the principle of complementarity, as John Dugard noted, the ASIL report and others of us think that it would not be a huge effort on the part of American lawmakers to harmonize our criminal law with chargeable offenses that would be be parallel to those over which the court has jurisdiction. You know, in the end, there is nothing that some people do have this ambition for a court that is in charge, that is a sort of a global Supreme Court that has final say over national governments. And some people think that the Assembly of States Parties is the way to go. But that's, as a practical matter, I don't see how that works out for them. And I think that if you went to France, say, and said, you know, some of your lawyers actually think that they can use the International Criminal Court in a way that would circumvent the United Nations Security Council, where, of course, France is a veto power, that the Quai d'Orsay would laugh at them if they tried to propound that. So it's, you know, the answer is the answer is that, notwithstanding the ambition, there are actual real-world constraints and checks that operate on this body as they do on other such ambitions.
Can I just add, Admiral, that, I mean, I think it's an excellent question, which gets to what really is my principal thrust, is that we have to talk about the reality of Washington. And it is very difficult in Washington, particularly before the Senate, to dispel concern that something might happen before an international institution. It's why it's difficult to get through any multilateral treaty, because no executive branch official is going to say that it's impossible that something might happen. I personally think the likelihood of any American ever being brought before the International Criminal Court in The Hague borders on zero. But you have to say, well, this might happen or this could happen. It's like the law of the sea treaty. We got pressed very hard to say, well, but isn't it possible that even if we are not going to the International Court of Justice or to the law of the sea tribunal, that some arbitral panel might possibly decide that the U.S. Navy had acted illegally, and an international body could rule against the United States with respect to our military activities? Well, Senator, I guess that's theoretically possible. Just what I said. Absolutely, we should not become party to the law of the sea treaty. And you know, that's just a treaty on the seas. When you're debating whether we should become party to a treaty that would deliver our American service members, at least theoretically, to The Hague, it's a steep argument for the executive branch to argue to the Senate that is when it's so easy to argue the other way. So, I mean, the arguments I would make to answer your question of, well, there are lots of protections and there are many safeguards, and we don't think that would happen, and look at all the safeguards that are built in, and it's the principle, as both John and Todd have said, of complementarity, that the ICC only complements the U.S. system. Well, but Mr. Bellinger, isn't it possible that a prosecutor, if the U.S. government declines to prosecute either Lieutenant X or Secretary of Defense Y, isn't it possible that the prosecutor under pressure could decide to bring an action on his own? Well, Senator, theoretically that is possible, and you begin to rapidly lose your argument.
Other questions?
I would just like to respond very briefly by saying that I think the answer to your question is to point out that there are other international tribunals. There's the International Court of Justice, albeit one without criminal jurisdiction, but the United States is a party to the ICJ statute and does frequently appear before the International Court as defendant state. And I think I'd also point out that there are many earlier attempts at creating an international criminal court. So this is nothing new. It's not part of the new movement in the direction of globalization.
And at risk of wearing out my welcome, I would have to respond to that, John. And I argued the last case before the International Court of Justice accepting its jurisdiction. But a senator is going to say, well, but Assistant Secretary Dugard, isn't it true, though, that in the Nicaragua case, that when the United States actually withdrew from the jurisdiction of the International Court of Justice, that it went ahead and heard the case against the United States anyway and ruled against the United States and found that it had acted illegally? So doesn't that in fact prove that we have to be suspicious of these international institutions?
Okay,
Yeah, that's right. Yeah. Maybe you just leave the Hague Invasion Act on the books, and just tell me, look, if things really get crazy, we still got this one. I don't know.
Great. Next question. Yes.
Yes, hello. My name is Robert Drayson. I'm with the Embassy of the Netherlands in Washington, D.C. We welcome all Americans to The Hague, but preferably not in an invasion. No, my question concerns the famous, let's call it, unsigning letter. And the read that my government has always taken of that letter was that it was primarily a political statement that did not have any legal implications because the signature was still standing of the United States. Now, I would like to hear the views of this excellent panel on this matter, and also on whether, politically speaking, you would expect the Obama administration to take any steps regarding that letter, or that they will just disregard it and let it be. Thank you.
Thank you for the question. I haven't had a chance to really throw my 2 cents in, so I'll start with, if that's okay with. And there's a lot more that could be said about your question, but the question is the unsigning just a political act, and then is there just a question about to have a different political act? There is some international law implicated here, although the boundaries are quite uncertain. The treaty that regulates the effect of signing and ratifying treaties, it's called the Vienna Convention on the Law of Treaties, has a provision that says that when you sign a treaty, even though you haven't ratified it yet, that you are bound not to take steps that would defeat the object and purpose of the treaty. Now, quite honestly, nobody entirely knows what that means. Does it mean very much of an obligation, or are there extensive obligations associated with it? But a lot of international lawyers think there's some obligation associated with signing a treaty while other states wait to see whether you're going to join. But interestingly, that same article actually goes on to say those obligations continue until such time as you make your intent clear not to become a party. So whether it's a good policy move or a bad policy move, what happened in 2002, the United States actually followed that provision to the letter in making its intent clear. In fact, it's hard to imagine a way of making your intent clearer than sending a letter to the Secretary General. That had not typically been done before. Most states, including the U.S., had been rather vague about their position in those issues, but the provision in question actually invites you to make your intent clear so that other nations know where you stand in respect to the treaty, and that became very clear in May of 2002. And to the extent there were any legal obligations associated with the signature, the Bush administration stated quite clearly they thought those would end at this point, given the announcement that was made. The very interesting question, which I think people could debate, is what is the status, nevertheless, of the signature after that act? It isn't physically removed. It's not, as John says, not snipped out. One could imagine the argument that the Obama administration could, in effect, reinstate the legal obligations, whatever they are, associated with the earlier signature, by simply now stating an intent to eventually become a party, probably without saying when that would happen. And with that, there's just a question, would that then move the United States into the status they had before May 2002 by the new statement of the Obama administration? Again, with probably an undefined set of legal obligations to the court. I could imagine that debate happening.
Well, just having been at the White House at the time of the so-called unsigning, it had a mixed purpose. I mean, there were certainly some in the administration who saw it as a political statement, and John Bolton famously said that it was the happiest day of his life when he signed the letter stating that we didn't intend to become a party. But it also was intended to, and did, as Kurt said, have legal significance, because a signatory to a treaty does have obligations to take no actions contrary to the object and purpose of a treaty. And the concern was that if we negotiated a whole maze of these Article 98 agreements to protect our American service members from being turned over to the ICC, that we might be accused of taking actions that were contrary to the object and purpose of the treaty. And it's quite clear, as Kurt said, that if you state under the Vienna Convention on Treaties that if you notify the depository of your intent not to become a party, you have made your intent not to become a party clear, and it frees you from your obligations as a signatory. And so we did very clearly feel it had legal significance, and it did. And I actually do think, and I should have mentioned this as far as things Obama will do, I would bet you money that in fact, as part of this tone change, that President Obama, in fact, I'm surprised they haven't done it already in the first 3 months. I think it has to do with the fact that there are just not enough officials in Washington. But this is more, I think, low-hanging fruit, that they will, in fact, notify. Now, I wouldn't go quite so far, because they can't say, well, we're writing to tell you we do intend to become a party, because they really can't say that. So they will have to write a kind of a clever letter that says, we are writing to you, the depository, to notify you that the last letter sent to you has no legal effect. And I predict that will happen.
The only additional complexity is that those Article 98 agreements pertain to Article 98 of the Rome Statute, which is to say, we argued that there was no contradiction in signing those agreements with your obligations under the Rome Treaty. So you could say that we might have, that we had the legal authority to act in contravention of the Rome Statute by filing the Bolton letter, but that we didn't actually do that. And I think that that's actually somewhat convenient in terms of repairing the relations.
I think we can take maybe a couple more questions, but I should also note that one of our speakers is going to needs just to get to the airport, I think, pretty soon. So if you see one of us leave pretty soon, that's because of that. So why don't we just try to take another question or two? Back there.
My question is sort of a follow-up to John Bellinger's analogy to the Law of the Sea Convention. Assuming that Obama would do what you say he probably won't do, and that is seek changes in the 2010 conference, what is the incentive for other states to go along with us on that, on the change that we would ask for? Looking at the Law of the Sea Convention, we have President Reagan's statement that it was fatally flawed. Then a group got together, the boat group, and they cured the flaws. And here 15 years later, we still have not ratified. Can you comment on that, please?
Yeah, I mean, it is a great question, and that's right on the money. The difference between me and Todd is I think Obama has to go into the review conference seeking changes, because if he's going to go back to the Senate to seek approval, he has to say to the Senate, see, President Clinton said it was flawed, but I got these changes, so now it's not flawed anymore, and so now you should approve it. He can't go to the Senate to say, President Clinton thought it was flawed, I haven't made any changes, it's really not flawed, I urge you to approve it. I just don't think that'll work. So I think that they will have to go in with the extremely heavy lift into the review conference seeking some changes, and it will be extremely difficult for the reasons that I saw. And then yours is sort of the nail in the coffin, because behind closed doors there will then be this great debate amongst, as I said, the pragmatists and the realists. And the pragmatists will be saying, well, let's make these changes for the United States because we really want them to become party. The idealists will make your point, which is, well, one, we shouldn't give in to American exceptionalism, and moreover, look what happened last time. We made changes to the Law of the Sea Treaty, and they still didn't become party. So let's wait to see if they become party to the Law of the Sea Treaty first to prove that when the international community makes changes to a treaty in deference to the Americans, that they can actually get it through their Senate. So I do think the fact that we've been unable to get the Law of the Sea Treaty through the Senate, even after the international community made changes in response to President Reagan's concerns, will really mean that we've got to get that. We've got to prove we can get the Law of the Sea Treaty through before the international community agrees to be essentially sort of fooled again. So, excellent question.
Why don't we take one more question?
John Brooks of North Carolina, and I want to focus on the conceptual suggestion that we seek restriction of the jurisdiction of the ICC to referrals from the Security Council. And in doing that, are we saying essentially that those permanent members with veto power will never be subject to the court? Or are we also amending that to say there will be no veto power in that instance?
I don't want to take all the time here. I will say, just factually, no, we wouldn't be giving up our veto, and that, of course, is the principal complaint, which is if you subject a referral to the veto power of the Security Council, aren't you putting yourself, the United States, in this special position, which is exactly why sort of the idealists will say that we shouldn't do that. I will tell you that we haven't talked much about Russia and China, but they're in pretty much the same. They've both signed, but also don't want to become party because they really don't want to become subject to the ICC either, and they've been very happy over the last 8 years to have the United States essentially take all the international flack. If the Obama administration starts getting cozier with the ICC, you will, I think, begin to see Russia and China becoming more agitated about it.
Thank you. I'll let Scott Sullivan close here, but before that happens, let's thank our panelists for terrific discussion.
Thank you, Kurt, and Todd. I am the 28th speaker. Anyway, a couple of things. One, I really appreciate your coming. We hope that this has been a beneficial conference for you. We hope that it's been an enjoyable experience for you. I've got to tell you, though, that some of us get together, Kurt, myself, and others, and we try to scope out the themes that we want to have, and I think we hit it pretty well this year. But there's someone who does all the work. And that's Tiffany Servey, and I'd like to recognize Tiffany for handling all the paperwork and all the registration. Now the problem is, I wish I could say, well, Tiffany will be right here next year to do the same thing, but on Tuesday she's leaving Duke Law School to go with a law firm in Charlottesville. So Tiffany, we're going to very much miss you, but we appreciate all the hard work you did on this conference. Thank you again. One last reminder, those evaluation forms, I read every single one of them. So if you haven't filled it out, Dusty, if you haven't, mail it back to me, right? Or call me, I know you will. But we want to try to work very hard to make next year's conference better than this year's, and we solicit your views on that. So again, we thank all the panelists, we thank all of you, and Godspeed, and you just travel home.